Today, we are diving into a story that, on the surface, seems almost silly. I mean, it starts with a few cactus plants on a patio, but it ends with this huge legal showdown, and the winner was decided by a single, tiny, and honestly pretty surprising technicality.
You know, if you've ever lived in a neighborhood with an HOA, you probably know that feeling, right? You see that official-looking envelope, your stomach drops a little, and you're just wondering, okay, what rule did I break now? But what happens when the HOA is the one breaking the rules? Well, that's exactly what we're going to get into.
So here's how we're going to break this all down. We'll start with the cactus itself, then we'll look at the violation letter that kicked everything off. After that, we'll dig into this very specific 10-day rule that turned out to be critical. Then we'll see the judge's final ruling and finally find out how it all came down to a $500 technicality.
Okay, so let's set the scene. Our story starts in Scottsdale, Arizona. And it's a classic setup. You've got a homeowner, his patio, and of course, the homeowners association watching over everything.
All right, so who are we talking about here? On one side, we have the homeowner, Steven Kramer. On the other, his HOA, called the Camelback House Association. And stuck right in the middle of this whole thing, a few pencil cactus plants.
Now, this is a really key detail. Before he planted a single thing, Mr. Kramer actually did his homework. See, back in 2017, he got permission to build his patio, and then he specifically asked them, hey, is there a plant policy? He was told nope, so he went ahead, he planted his cactuses, and for years, everything was totally fine. And then, almost 3 whole years later, that letter showed up. And this is the exact moment a simple disagreement about gardening starts to turn into a full-blown legal challenge.
So Kramer gets the violation notice, and right away he sends a formal written response. And then, crickets. The HOA just went completely silent for 8 entire months. This gap right here, this is the first really critical piece of the puzzle.
You know, this timeline just lays it all out so clearly. You've got the violation notice in July, Kramer's response in August, and then this massive 8-month black hole of silence before the issue just pops back up again. It was that huge delay that finally pushed Kramer to file an official petition, basically saying, hey, you guys didn't follow the proper procedure.
So, what procedure did he claim the HOA failed to follow? Well, it all comes down to a very, very specific piece of Arizona state law.
And this right here is the exact legal question that the entire case really hinged on. We're not just talking about some flimsy community guideline here. We're talking about what Arizona state law actually demands.
Okay, for all you legal eagles out there who want the specifics, here it is. Arizona Revised Statutes, Section 33-1242C. And it's super important to remember, this isn't just an HOA suggestion. It's a requirement, baked right into state law. So here's exactly what that law says. Within just 10 business days of getting a homeowner's response, the HOA must, and that's the key word, they must reply in writing. And that reply has to do a few things. It has to name the specific rule that was broken. It has to give the full first and last name of the person who saw the violation. And it has to explain how the homeowner can contest it. It's all about due process.
Okay, so now that we know the rule, let's jump back to the hearing and see how the judge actually applied it to the facts of this case.
The HOA's argument was pretty straightforward. They basically said, look, our first notice had all the info, so we didn't need to send another one. But the judge pointed out 2 huge problems with that logic. First, the law is crystal clear. You have to respond to the homeowner's letter, no exceptions. And second, that first notice they sent wasn't even compliant to begin with. And this quote from the judge's decision just nails it. The notice said the violation was spotted during a recent inspection, but it never actually said who did the inspecting. The only name on the whole thing was in an auto-populated signature, and the judge ruled that just doesn't count. So when you boil it all down, it came to this. The HOA made 2 critical, unforced errors. 1, they didn't respond within the legal time frame. And 2, their original notice was defective from the start. In the end, these procedural failures, they meant everything. And that brings us to the final outcome. The homeowner won, but I'm telling you, it was not for the reason that you might think. The judge ordered the HOA to pay the homeowner back his $500 in filing fees. A clear, undisputed win for Mr. Kramer. And this, right here, is the most important lesson from this entire saga. The judge never even made a ruling about the cactuses. The fight wasn't really about the plants at all. It was about the process. Kramer won for one simple reason. The HOA failed to follow the letter of the law.
I mean, look at it this way. The homeowner's victory was based 100% on the HOA's procedural mistakes and absolutely 0%, on whether the cactus was actually a violation or not.
So what's the big lesson here? It's really simple. Procedure is power. It doesn't matter if you're a homeowner or if you're on an HOA board. This case is proof that knowing the specific rules and following them to the letter can be the one thing that decides the entire outcome of a dispute.
It's a pretty powerful thing to keep in mind, isn't it? So maybe the next time you get one of those notices from your HOA, you might find yourself asking a whole new question. Are they following the letter of the law?